Good morning, sir. You're Brandon Bell, and this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10, and
right out of the gate, we've got a big reveal. The defendant pled true to multiple violations. In probation terms, that's basically admitting, yeah, I messed up. And trust me, when you're already on a deferred sentence, this is the last time you want to be racking up violations. The stakes just jumped way up.
there was not an agreement on probation for aggravated assault with a deadly weapon, and I've received that updated report. Has everyone had an opportunity to review that report?
I have, Your Honor, in addition to some medical documentation that Mr. Berman has provided.
Was that provided to me?
Not.
Okay. I'm sorry.
Probably not.
Okay. Is it, what should it have? Do I?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
I don't know what you're talking about. Yeah, I mean.
These are medical records from Spindletop.
Okay.
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working.
Okay.
Which I think.
Hold on, this case just got a major twist. The defense brings up a catastrophic injury. He literally lost part of his leg in a workplace accident. That's not small talk, that's a huge factor in sentencing. Judges always consider medical hardship, but does it outweigh repeated probation violations? That's the tension building right here.
That need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know that's been a concern, but I had some difficulty with that portion of the case.
Okay.
And here's where things get emotionally complicated. The victim, the complainant, is the one who originally pushed for probation and even stood up for him in court. But now? The defense hints that neither party obeyed the no-contact order. That's a massive red flag in domestic cases. Are they ignoring the law or ignoring danger?
If the court would also remember, she was expecting another child, they are expecting another child, and
Okay.
so
what? Go ahead and make argument, and then I'll.
She's also controlling the checking account. He's getting settlements, and he's providing the money to her for the children. They still have a house together, but he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, I have some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there's some program that he can have that's outpatient, to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report he is reporting, it's not like he's not.
Listen to this part closely, because the defense is painting a full mitigation picture: mental health issues, physical disability, financial responsibilities, newborn on the way, even attempts at compliance. This is classic defense strategy: frame the defendant not as defiant, but as overwhelmed. But will the judge buy it?
Reporting he's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And you couple all that, I've had extensive conversations with his wife. I've tried to tell her the way it has to be as of yesterday. We've talked over the phone in the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8? Ms. Lopez?
I mean, I guess it kind of depends on the
Just in the context of what she has to say.
yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair? Affirmative record reflect. Ms. Lopez is identified the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition 9. Can you explain that to us a little bit?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that they are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation center.
Yes, we need updated phone numbers, addresses, things like that so that we can specifically talk to the defendant.
And he pled true.
Okay, this is where probation gets real. Failing to keep contact info updated isn't a tiny mistake, it's a big violation. Officers need to reach you directly, not through cousins, roommates, or someone who might tell him. Lost contact equals lost trust. And trust is the entire foundation of probation.
2 additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like Spindletop, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that may be a recent thing, and so that may not be applicable. medical yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated